Okay, it is 8:30 p.m. Week 10, the final lecture for the quarter. The quarter ends next Friday, a week from Friday, which I believe is the 16th of March by 11:59 p.m. Central Standard Time. All assignments have to be in. I will be going over that again. And so we've reached a point where I am going to, your final grades will be due that following Monday after the 16th. And so anyway, I'm going to go ahead and get started with this final lecture. Let me go ahead and share my screen. Okay. And as you can see, course homepage again gives information, structure information, other information. I have added something to this since our last time, and that's the critical skills video. If you take time to copy and paste this link, it will lead you to a very, very, very important video that you can take a look at, because it will be beneficial in helping you understand critical skills. You might want to save that and use that in other courses as well. And then our rubrics, as we normally have here. We're going to go all the way down to week 10. Here we are. This week, plea bargains. We're going to talk about plea bargains tonight. And so it'll be beneficial for you to pay attention to the lecture tonight. And again, reminding you, many of you lose points because your assignments are not the proper length. You don't cover the issues. You have to make sure you cover the issues. 5 points for explaining what a plea bargain is, and then 5 points for the next issue, and then 5 points for the next. And then APA requirements, citations, and references. I say this at the beginning of the quarter. I go back again to the top. All written assignments should be in APA format. That means citations in the body of the paper and references at the end. And many of you will do one or the other and then wonder why you lost the points. It's either right or it's wrong. It's not a little bit right, a little bit wrong. You don't get credit for just having citations or references. You get credit for satisfying the APA requirements. And then spelling and grammar as well. Make sure you run your papers through Grammarly. And if you, not a lot of you this quarter have had that problem, but making sure that you have enough critical thinking in your papers and that you have not just copied and pasted. Please use reliable resources. Again, I remind you, only a few of you have done this, maybe even one person or two. Wikipedia is not a reliable source. Never use Wikipedia. So that's the assignment. And then week 11 assignment is here. There will not be a lecture next week, but I will comment about that in a little while. So now let's move down to the course project. Week 10, pretrial motions. Again, we're going to be talking about that in just a few minutes. 2 to 3 pages in length. If you have 1.5, if you have 1 page, 1 paragraph, you're going to lose 5 points right off the bat. And explain how a motion to suppress applies to statement on the scene. Explain how a motion to suppress applies to confessions. Explain how motion to suppress applies to physical evidence. And then, again, 5 points for the APA requirements in spelling as well. That equals 100 points. Okay? You want to make sure that you have done it. And then a reminder that this is the last lecture, and the recording will be here at the end of this session. Week 10 announcement. What to expect before and during trial. Read chapter 17 and 18, which I previously sent you the PowerPoints to make sure that you have them in advance so that you will know, in addition to what's in the material that was written in the textbook, as well as the outline that I send you of information that helps you as well. Then complete the activity pre-trial and trial expectations, and then down here, your discussion assignment, jury selection, voir dire, and then the deadline, of course, is tonight, 11:59 p.m. Central Standard Time, and reply post Saturday, 11:59 p.m. Central Standard Time. Finally, your written assignments, plea bargain, I already covered that. You know about the quiz. Again, I have recommended that you do that on Sundays, but many of you have gone on and done it before that, and your scores reflect that. I said if you wait until after you've gone through all the material at the end of the week, then you will find yourself with a higher score. And then project filing, pretrial motions. You're going to do the written assignment for that as well. So that's the project. And then my motto at the end, we've already talked about adversity as springboard to success. You know what that's all about. It's time for you to finish strong. And we're coming to the end, so you want to make sure you do that. So now let's take a look at the calendar again, just for a quick gander. I have students that sometimes will ask me when our assignments due. I said, go back and look at the announcements. And then if the announcement isn't able to be retrieved by you, you can't. You should always have had your calendar from the very beginning. And this is the calendar for the month of March. And it tells you exactly where we are right here. So we're doing your reading assignment. Oh, yeah, we're right here, the 5th. So this completed February here. So March 5th this week, and then your initial posts, your lecture, your reply posts, your quiz, your course project, and then your written assignment as well. Next week, notice this, Monday, Tuesday, same routine, except the quarter ends on the 16th. Here is my notice to you. Quarter ends at 11:59 p.m. Central Standard Time. That means that all papers have to be in. So don't say, oh, I thought it was due the following Sunday. No, because after the 16th, if it's turned in after that, you're not going to be able to get a grade. So if it shows up and it shows the 17th, I will not give you points. It's a violation of the school policy to do so, unless there's some special arrangements that I won't talk to you about that have been made. And so anyway, the point of the matter is that all assignments must be due on the 16th, so that by the 19th, which I was telling you, all your grades will be in. So I'll be spending that weekend grading all of your assignments, catching up, and submitting your final grades. Let's go and look at module here before we get to the lecture. Again, the assignments. There's no reason why a student don't know what the assignments are, because I go over them 3 times or 4 times at least at the beginning of every lecture. Plea bargains, the fact pattern that's given here, 2 to 3 pages, and then you're going to answer these questions. They are the same ones that are in the rubric. I already encourage students to take your rubrics out to make sure that you satisfy the column in the rubric to maximize your points. That would be like my little sheet help me remind myself. Your discussion posts, and then 2 to 3 pages for the motion to suppress, confessions, and search of the vehicle, and all this good stuff with ABC, Alan, Betty, Charlie, that you have met since the beginning of this quarter. And I already told you what the requirements, and then of course the quiz. So now let's go to the lessons tab. Lesson content. And with the lesson content, it gives us the objectives, gives us the reading, which we've discussed already. It gives your assignments that I already covered as well. And then we come down to the pretrial expectations and trial expectations. So this talks about pretrial motions. Again, I'll be talking about that in just a minute. Various motions. Some pretrial motions are listed here. Motion to dismiss, motion to suppress physical evidence, a motion to disclose a confidential informant, plea bargaining, which we'll be talking about in detail, right to a jury trial. And then do this little exercise here. What is an arraignment? An arraignment is, as it says at the top, an appearance before a court of law for the purpose of a criminal charge, to answer a criminal charge. At the arraignment, there's only 2 things you can say generally in most instances: guilty or not guilty. You don't talk about the facts of the case or none of those. That's all it is. It's a procedural process that takes you through. Then, pro se representation. That means the person represents themselves. Flip that over. And then bail, sum of money posted to ensure that the person appears in court. So I'm not going to go over the rest of them. So you want to take the time to go and familiarize yourself with them. And then sometimes students say, oh, I already know. Go look at them again anyway, because make sure that you refresh your recollection memory, because some of these things are on the quiz. I'm not going to tell you which ones are, because I know the quiz already. All right. So those are your assignments for this week. Again, reminding you, in week 11, very quickly, your assignments: appeal and right to counsel. It's 2 to 3 pages. Right away, all your written assignments are 2 to 3 pages. Discussion post is on the death penalty, and then sentencing and appeal. Okay, again, it's 2 to 3 pages, and I already told you about APA and all of that based on the module. So I am done with that, and I am going to go right into our lecture. We're going to cut off at 10 o'clock wherever we are. I'm going to, I should be able to do them both because these are pretty straightforward. But I'm going to start out with the pretrial process. Now, you should be aware of the fact that in pretrial, it is when all your motions take place, and that's probably the thing that takes the longest in pretrial. From the time a person is arraigned and then they have a preliminary hearing or indictment, the motions that are filed after that, and we'll talk about some of those motions I already mentioned, a few of them will take place. Now, remember, this is pre-trial, before trial. This is where most of the work is done to prepare you for a trial. This is when, matter of fact, I had to say all of the work is done to prepare you for a trial so that you can adequately have a defense. And you're going to start out by dealing with what is pretrial all about. Well, the fact of the matter is due process. Due process of law has been in the news lately, and all it really means is basically these 2 points. A notice of what your charges are, you get a copy of those charges, and then the opportunity to challenge those charges, to bring in witnesses on your behalf, to be able to produce evidence to support your defense, to be able to have evidence that would violate the Constitution not be used in a trial. And so some of these things are basic things and very important to you in terms of it. So here are the steps that take place. Your initial appearance, and then with your initial appearance, a lot of times what happens there, that's when your bail is set, and then your preliminary hearing or grand jury hearings will take place. You don't get them both, you get one or the other. We as defense attorneys, all the years I practiced as defense attorney, we loved the preliminary hearing because that gave us a chance to produce evidence at the preliminary stages that would cause the case not to go to trial. But at the grand jury proceedings are closed, and the prosecution is the only one there, and they're witnesses. The defense is not there, or the defendant, neither is there. And that the grand jury proceedings are different from a jury proceedings. The grand jury proceedings are sealed and kept. A true bill is voted, which a majority of the jurors vote for. Unlike in a criminal case, when you're dealing with a jury trial, it has to be unanimous in order to find a person guilty. Again, we'll be discussing that in a little bit later. And so at the arraignment, I already told you you're going to be pleading guilty or not guilty to the charges. If you plead guilty, of course, then you go right to the phase where sentencing takes place, okay? So that's how it starts out. You have a right to an attorney, constitutional right based on the 6th Amendment of the United States Constitution, established way back with Gideon versus Wainwright, a Supreme Court case that is a landmark case. And actually, there's a book called Ian's Trumpet. And then I'm holding up in my hand a video, which is a movie that Henry Fonda was in. Excellent. I use this for teaching my constitutional law class, but it talks about how the 6th Amendment changed and how this individual won their case to have a right to an attorney for all charges that possibly an individual could be incarcerated for. So if you can't afford to pay an attorney for an attorney is provided for you at public expense. All federal prosecutions, treason, felony, and in misdemeanor cases. Misdemeanor cases are cases that you can go to jail for up to a year and or be fined. A felony is above that. Anything a year and above that you can go to jail is a felony charge. So you're entitled to a right to counsel, and most states have the same right for individuals based on the application of the 6th Amendment to the states by the 14th Amendment clause of the Constitution. So all states have that. And here's what I was talking about, Gideon versus Wainwright, in which counsel must be provided to an indigent where this person requested a lawyer to defend him, but the judge didn't give him a lawyer, and he was convicted. So the Supreme Court said, no, the right of one charged with a crime to counsel may not be deemed fundamental and essential to fair trials in some countries, is in our country. So therefore, it is a right. Gideon versus Wainwright is the start of it, and then there were cases that came after that, which we will talk about one here. The Scott case, in which the Supreme Court ruled that no indigent defendant can be sentenced to prison without providing counsel. The court also held that counsel is not required to be provided if the defendant does not receive a prison term. So again, if a person is going to be just fined, it can be denied. But a fine is different. Remember, the key is if it's a possibility that you can go to jail. Not that you end up, but that is a possibility. And that was the Scott case of '79. Basically what they did was elaborated what was in the landmark case of Gideon versus Wainwright. The right to counsel is in Strickland versus Washington. The Supreme Court held the defendant has a right to what we call effective counsel. So what they did was they had a right to counsel established with Gideon versus Wainwright and applied through Scott. Now they add on the term effective counsel. Now, effective counsel is not something that is a set standard, but here's the deal. The deal is that your attorney should be knowledgeable in the area. In other words, a criminal defense lawyer should know criminal law. A real estate attorney may know it. I did various areas. I did areas other than criminal, but I was a specialist in criminal law. And so I knew criminal law inside and out. But the point of the matter is that when I represented my clients, I was effective counsel because of my knowledge. You can't have an attorney who's drunk in the courtroom, sleeps through the trial, or who are incompetent based on some of the things I said, or not prepared, because a person being incarcerated and their life is at stake. Specifically, it says in death penalty cases, it is especially important. But why does it say that? Well, that makes sense, because your life is at stake. You could be executed if the attorney is not effective. And so I've given you some ideas about what effective counsel consists of. And there are arguments made time and time again by people sometimes who get convicted. When they want to use this, they'll come back and say their lawyer didn't prepare well enough. Well, if the lawyer did some things that were within the standards and made sense in terms of reasonably trying to defend their client, and it didn't turn out the way that they thought, that doesn't mean that they're not effective counsel. Or put it another way, effective counsel is not only counsels who win cases, but effective counsel is also those who lose cases. But understand this very simply, and I'm going to move on from this, is that an attorney needs to be able to be versed and be prepared to provide the proper defense that a defendant is entitled to under the Sixth Amendment. Petty offenses. Well, summons to appear in court, like traffic violations, other minor offenses, we already kind of talked about that. You may not necessarily have the right to an attorney, but you certainly can have one. Laws permitting or requiring police officers to issue citations instead of making arrests are what we call petty offenses. Trials to determine guilt or innocence for minor offenses. These are what we call petty offenses. There's no jail time involved. So if there's jail time involved, it's not a petty offense. So here we get to the point of pretrial release. Pretrial release is generally the time when you deal with your bail being set. And so, as I said earlier, at your initial court appearances, charges are read. Individuals are informed about their rights. Pretrial release or detention takes place. And so that operates on the basis of whether or not bail is granted or not granted. Pretrial release is by what we call I bonds, the letter I, personal recognizance bonds. In other words, a person is released when it appears that they're not a flight risk. The offense is probably not a very serious offense. It's probably a misdemeanor that you get an I bond for. Very rarely are I bonds granted in felony cases. You could be released to the custody of another. Happens all the time in cases where minors are, or if there's some health issues involved there. Even being released to the hospital is the custody of another. Posting bond. Bond is generally 10% of whatever it is that the court sets. So let's say a $100,000 bond, you must post generally 10% of that, which is $10,000 in cash or property. Bail can be excessive, and some examples of that. I'll give an example I heard today. Many of you may have heard about this young man at a college in Michigan who is charged with shooting and killing his parents. And actually that's in an area right near us here. And many of my students here in this area and some of my own kids know people who knew this kid. But anyway, this young man's bail was set at $3 million. And so I saw today, I was looking at the hearing that took place, that his attorney moved to reduce the bail, saying that $3 million was an excessive bail. He had never been in any trouble before. He's not a flight risk. And they also said that he had never done anything. Though the bad thing is that this is the most violent offense that can take place, and that was murder. So the judge reduced it to cash. So his $3 million, which meant that he had to post quite a bit, or 10% of $3 million. And they reduced it, though, to where he had to post $1.3 million cash. And so as a result, the bail was deemed not to be excessive, and that's the way it is. We didn't expect that to be made. They weren't going to reduce it down to $10,000 or something like that. So pretrial detention takes place where you're not able to make the bail and you're maintained in custody. And then also for misdemeanors, there are many jurisdictions in our jurisdiction here in one of our big counties, Cook County. They've decided to grant non-violent offenders who couldn't afford bail, I bonds or very low bails so that they can get out. The idea of bail is to make sure that you appear in court, and that's the whole idea. It's a trust issue. And if you've had previous bails and you didn't come to court, then your bail is going to be higher. And then there are some instances where no bail is granted. I'll be talking about that in just a minute. In Stack versus Boyle, the Supreme Court held that setting bail higher than necessary violates the 8th Amendment as excessive. That's what I was talking about. So you should be aware of the fact that, excuse me a second, that there is no constitutional right to bail. The Constitution says that you have the right not to have excessive bail. That's what the 8th Amendment says. So anyway, this person was charged with subversive activities in violation of Alien Registration Act. Bail was set from $2,500 to $100,000, but later set for every one of them at $50,000. So that meant that they had less that they had to post. So the court sided with Stack, saying that the $50,000 was even excessive under the circumstances. So the court looks at all the circumstances to determine here whether or not. So again, the key thing is, remember this, is that the Constitution and the Eighth Amendment does not guarantee bail, but what it does is guarantee that you have a right to not have bail that's excessive under all of the circumstances that are involved, with some exceptions like now. Here's an example here. United States versus Salerno, the Supreme Court held that there is no constitutional right to bail under the Eighth Amendment. I already told you that. So this person was denied bail because he was a member of the mafia, the Genovese crime family, and a threat to the community. And he appealed, saying that it is unconstitutional to punish him for possible future crimes. The court says no, because the defendant was a known mafia member. And so under all the circumstances involved, this individual, even if they granted a high bail, would probably be able to make the bail and would probably be a flight risk and not make it to court. So therefore, and then there was also the possibility of a threat to the community. Except you should be aware of the fact that even those individuals behind bars that don't make bail, they have people operating on the outside that they give instructions to still that can be a threat to the community. So what they do, as a matter of fact, is try to at least take away the flight risk, because bail is not granted. So you get that very clearly by looking at this situation here. So when formal charges are involved, you have a right to bring witnesses forward, and you are given the right to use what we call a subpoena. A subpoena is a document that requires an individual to appear before the trier of fact, the judge, or you'll hear it in Congress or some other instances. But if they don't appear, and you heard this about one of the guys who is no longer part of Trump's organization recently here in the news, saying that he was not going to obey the subpoena, and they were explaining to him that he could be arrested. Well, that's the power that can happen if you don't obey a subpoena. Now, there's a regular subpoena, and then there's a document called a subpoena ducis tecum, which is not here. And it's usually in a civil case, but sometimes in a criminal case, where it means not only do you appear, but you also bring the documents that pertain to any transactions that you have in your possession or knowledge of. That, for example, is what would apply in that subpoena situation with that guy. They're asking for the emails that are involved for Congress and for the special investigator, Robert Mueller, to be able to view those things. And so he has the power of the subpoena and the subpoena ducis tecum. Prosecutors, you should be aware, they kind of like have a lot of discretion. They can decide what charges to bring, and you know, they can't be prosecuted or either should I say sued for not bringing charges that you think they should be. For example, there are people who believe sometimes that second-degree murder cases are brought forth in situations where the public or someone else might believe it should be first-degree murder. But you should be aware that what most prosecutors do is bring charges that they know that they can or have a good chance of being able to get a conviction. And it doesn't make sense for them to bring charges for something that they know they can't get a conviction for. Prosecutors have immunity, as I said already, from damages for depriving defendants' constitutional rights, such as bringing charges against someone, then later find out that that person was not the right person. Now, the prosecutors have immunity, but the police and others involved may not have it. The judge might. But here's the difference, is that if the law enforcement people have evidence or information or have done things to keep the individual incarcerated when they knew otherwise, then they can be sued. The prosecutor, if they participate in the fraud, can be lose their immunity for damages and can be sued. A document called an information determines the sufficiency of the evidence, and that information is a formal document that is submitted to you with all the charges and gives the basis for the charges and the statutory stuff as well. It's a written document. Preliminary hearing, again, is, as I talked about earlier, a hearing that takes place to determine whether or not there's adequate charges for the issue to go to trial. In United States versus Armstrong, the Supreme Court held that to establish prosecutorial discretion on the basis of race, the defendant has to prove that those who were of different races were not prosecuted or treated differently. In this case, Armstrong claimed that he had been discriminated because he was African American using crack cocaine. But his problem was he couldn't prove that prosecutors had not also prosecuted whites that were also guilty of the same offense. It's a pretty hard burden to overcome. So that is an argument that I've seen made, but not a lot these days. So the grand jury, I talked about that already. The true bill, that's when the majority agree on the charges. Remember I said not necessarily that it be unanimous, but the majority of the grand jury. Potential jurors should not be excluded from the grand jury based on race or gender. And so the individuals who are jurors should be able to be excluded on other bases, but not on race or gender. Acts as a shield and a sword. As I already said, the grand jury, protects, but it also cuts. And we, as defense attorneys, say that it cuts. Not one of our favorite decisions to have the grand jury, but the courts, the prosecutor can decide to bypass preliminary hearing and go to the grand jury. Witnesses, but we always try to argue when we know that's going to take place that the individual has a right to a preliminary hearing. What we're doing is just making a record. We already know what the judge is going to say pretty much, but we still say it anyway. Witnesses are protected by the Fifth Amendment. In other words, they don't have to speak. Witnesses do not have the right to counsel. And then indictment is issued after, if a true bill is granted. Now, this is a case right here that we defense attorneys, we do not like it at all. The Supreme Court held that witnesses may not refuse to testify in front of the grand jury based on the argument that the evidence was based on illegal search and seizure. In other words, what the Supreme Court held is that evidence that's illegally obtained could be used at the grand jury stage. Now that right there, and then remember, defense attorneys don't have an opportunity to appear before the grand jury. So in other words, evidence that would later on be deemed to be, not allowed in trial is allowed in grand jury based on the Calandra case. And this is what the rationale of the court was. It says he took the Fifth Amendment, moved to suppress the evidence, stating it was illegally. The court said no, that the exclusionary rule, which is the rule that says that all illegally obtained evidence should be removed from trial, doesn't apply to grand jury proceedings. And the reason why they said that is that they said that the grand jury is an investigatory tool, and that at this stage, it's an investigatory tool to determine whether or not there's enough evidence to bring charges. And it may be very well later, based on motions that we're going to talk about later, that even if it gets past the grand jury, that it still may be tossed out because the evidence cannot be admitted. In a regular trial, the illegal search and seizure is a violation of the Fourth Amendment, and a properly filed motion will allow that information to be removed from consideration during the trial, therefore weakening the opportunity of the prosecution to. So what it really says here is that the grand jury gives the edge to the prosecution, but then later on it swings back to the defense. And so, but it still, we say it doesn't make any sense, but it is what the court says, and it's still the law today. Extradition. When a person is, take for example that young man that committed that offense in Michigan, and that's where the offense took place, at his college, where he killed his parents. Then he ran back to Illinois, where he lived and where he was from. And so if they arrested him here or in another jurisdiction, in another state, then they could extradite him back to Michigan. And so it just means simply that you can't get away from being tried on a case just by leaving the jurisdiction. And it's agreement between governments and states to prevent an escape. And then there's the Uniform Criminal Extradition Law that sets out the procedural rules, which I won't go into in detail, but there are certain procedures that take place. I had a young man that I represented many years ago in my first very serious criminal case, a double murder. He committed the crime here in Illinois, and then he fled to Texas. They arrested him in Texas, and he had an extradition hearing. Or you can waive your right to extradition. Generally, what we tell our clients is you might as well waive it because it's just a perfunctory process. It's a procedural process, and you're going to end up back here anyway. Then there's extradition between various countries. There are some that the U.S. does not have extradition treaties with all countries, such as Russia, of course, and then there's some other countries. And then there are some countries where if a person is going to be subjected to the death penalty and they're fleeing to a jurisdiction which does not condone the death penalty, they will not extradite that individual back. So the bottom line is that people will flee and try to get out of the country. Once upon a time, they used to try to do that with Mexico, but that has changed. Definitely not to Canada anymore, but some other countries that don't allow extradition. Here's what I was talking about earlier. The European Union repeatedly refused to extradite persons who would face the death penalty. And so that's what I was talking about a few minutes ago. I won't go into that in detail. Now, this, when I was in law school, it confused me to no end. Because when we were in law school, I give you guys just a touch of what these topics are. We go into, I mean, deep analysis of issues. So therefore, we get a deep understanding which constitutes the basis for us charging there's good fees as lawyers because the fact that we know details just not on the surface of what you read. Anyway, in joinder and severance of parties, it's a basic process which determines whether defendants can be tried together or separately. And it kind of follows this process here. A separate trial is required if the prosecution uses evidence against one defendant which has nothing to do with the other defendant. And that has happened in a number of cases that I've represented people in, where I had a young lady I was representing, and they were charging the individuals with switching tags on the store items, which was theft, basically, to a lower price, and paid that lower price. Well, she didn't do that. She had proof that she had made her payments. But one of the first things I did was move to separate her trial. And I was granted a separate trial for her because she didn't participate in that activity. Some people say, oh, she was with him. Says, no. I was able to prove otherwise. And then there are other times when, for example, a person wants a jury trial and another person wants a bench trial. So the other says that in their inconsistent defenses, where there are different defenses from each one, if there would be prejudice against one defendant based on something you might hear with another, the trier of fact might associate it with that individual. Or in the final one, if a defendant decides to testify, but the other person does not, because then if they're tried together, it could be argued that, okay, that person didn't testify, which they have a constitutional right under the Fifth Amendment not to testify, and that shouldn't be held against them. But the trier of fact might say, oh, they didn't testify, so we're going to hold that against them. But if they're in a separate trial, that evidence that the other defendant testified cannot be brought into the trial where the person does not testify, because it would be a prejudice against them or an assumption. Joint trials. Each defendant receives a fair determination. And so that's when everything else is consistent. You're charged with the exact same things. And so as a result, there are joint trials. So we file what we call a Bruton motion. That's what we call it, where what we do is we argue it based on this case. This is what gave us the right to do separate trials, where the Supreme Court held that if one defendant testifies and the other does not, the defendants must be tried separately. Bruton and Evans were tried jointly for armed robbery. At the trial, a witness testified that Evans confessed that he and Bruton had committed the robbery. Well, the testimony was admissible for Evans because Evans confessed. The testimony was inadmissible against Bruton because it was hearsay, because Bruton never said anything. So you can see how it makes sense when you think about the Bruton case. We're able to file a motion because there are inconsistent defenses, because there's evidence that's different against each one. Therefore, they have a right to a separate trial in order to give them a fair trial. So here are some of the pretrial motions. These are just some. These are some that most of us lawyers go through the whole litany. And, you know, people should be aware of the fact that there's a Speedy Trial Act, but that when we are going through the motion stage, we usually get continuances in order to give us time to prepare and present these motions, which stops the clock from running. It's what we call tolls the statute of limitations. So therefore, 120 days, which we had in our jurisdiction in Illinois, could be a year because of the fact that various motions that we need in order to prepare our defense. So one of our motions that we use at the beginning, and we'll use it sometimes later, is a motion to dismiss. The evidence is not adequate in our position, and we lay out why we think it is not. And a hearing. Motion to determine the competency of the witness to stand trial. So what we're dealing with there is the issue of insanity, maybe the fact that that individual was drunk but not willingly, or that the individual was drunk and didn't know what they were doing. We can still try that. Or that the individual was a minor, those kind of things. But generally, competency we're dealing with the mental condition of the individual or the insanity, where we will file a motion to have our client examined by a psychiatrist. A motion to suppress evidence, evidence that's illegally obtained, as I talked about earlier. And so that goes to any kind of evidence that's seized improperly and violates the constitutional right of that individual. We filed a motion to have that evidence thrown out of the case. Motion to suppress confessions or admissions or statements because they were not given voluntarily, or because the Miranda rights weren't given properly, or things of that nature. So we file a motion to take a confession that's given that might be very detailed and have it tossed out. That's either written or oral confession. Motion to suppress the pretrial identification, saying that the pretrial identification was tainted, and that as a result, for example, like a lineup. Let's say you have a lineup and a person was in the lineup and everybody is 6 feet and 6'2" or 6'3", and that the one who's alleged to be the defendant is under that 5 feet. Well, that would be a suggestive lineup. Or everybody, the defendant is identified as Hispanic or black, and all of the other individuals in the lineup were not. Or to carry it to extreme, that the individuals are in the lineup and they're wearing police uniforms and the defendant is wearing regular clothes, those kinds of things. So anyway, things that are suggestive as well. Then there's what we call show-ups, where you have pictures that are given and people will look at the pictures, and very suggestive in those kind of situations for various reasons. Motion to disclose the identity of an informant. That is somebody that the prosecution wants to protect, and we say we have a constitutional right to know who that is so we can determine the truthfulness of that individual prior to trial and prepare an adequate defense. So we'll file a motion for the prosecution to identify who the informant is. Motion to change venue. That's when a trial needs to be moved to another area because the person couldn't get a fair trial in that area. Motion for continuance is a usual motion that we file. Again, I talked about that earlier because we are trying to get information and details. Some more? Okay, let's see. Before we leave that, in here, one of the motions that they don't have is a motion for discovery or disclosure in some jurisdictions, where what we do is we file this, actually one of our first motions, and we will file that motion in the court, and we'll ask for everything under the sun. We'll ask for exculpatory evidence or evidence that might exclude my client or prove that my client probably didn't do it, that the defense should be made aware of by the prosecution. And it's a standard form, and we call it, it's a catch-all. We ask for pictures, we ask for blood samples, we ask for all kinds of reports, we ask for statements, we ask for everything under the sun that the prosecution has. If you remember seeing the movie My Cousin Vinny, he was not aware, Vinny was not aware that under the laws of that state that they were in, and it was either Alabama or Arkansas. Anyway, doesn't matter which one, but the point of the matter is that he had a right to get the files of the defense, of the prosecution, to be able to prepare his defense. And so you would file a motion for discovery or disclosure in some jurisdictions, it's called, for the prosecution to disclose or present you with the information they have in their possession, so that you can prepare defense. So that's another pretrial motion that's not mentioned here as well. So arraignment, we already talked about that. You plead guilty or not guilty. Alford plea, guilty with protesting innocence. It comes in handy sometimes, but usually it's guilty or not guilty. In some jurisdictions, nolo contendere or no contest pleas, where you plead guilty but not admit the facts, so it's not an admission of guilt. But the bottom line is it takes place in some criminal jurisdictions, not here in Illinois so much, and it's not admissible in civil court. Now, here we go. This is going to spill over to the next one. We talk about plea bargaining. That's what one of the assignments this week involved. More than 90% of felony cases are subjected to plea bargaining. And that's an astounding number when people hear it. But you should be aware that it takes place. And the reason is because of one of the points here is that the system would collapse. There are not enough judges, there are not enough prosecutors, and the whole thing is that with the time period that you have for a right to a trial and a speedy trial, it's not enough time for even the prosecution to put together cases there. So bargaining between the defense and the prosecution, and the judge is involved with that as well, because the plea bargain is where the person pleads to guilt or admitting for a lighter sentence or a reduction of the charges that result in a lighter sentence or the minimum sentence when there's a possibility. And you know, plea bargaining is something that I used, but I only used it when I saw, after I did all of my motions, that it was clear that we were going to have a problem at trial. And I used it successfully in several cases. I used it in some situations where clients decided not to do it. For example, I had a young man that was charged with a very heinous crime. This was right near the end of the time I retired. He was charged with murder and rape of a meter maid who came to the house to turn on the gas, and he raped her and then murdered her. And I went through all the motions that I talked about earlier, and it was very clear that he was going to have a problem. Well, I immediately, after that, talked to him about a possible plea, and I did. I went and set up what we call in our Illinois jurisdiction Section 402 of the Illinois Criminal Code, and so we call them 402 conferences, and that's our number for plea bargaining. So I entered into a 402 conference with the judge and the prosecution, and there was a PSI, which we call a pre-sentence investigation, which was completed by the probation department to determine what kind of background this individual have, and a number of things in there, education and all of that kind of stuff. Well, anyway, this was a case where this individual was facing natural life. At that time, we had death penalty in Illinois. However, we were not executing those who were under 18, no matter what. So he committed the offense when he was 17, and he was actually 18 by the time we had this pretrial conference of the 402. And so anyway, I ended up negotiating a plea that said that he would serve 40 years. Now, at that time, 40 meant 20. So I went back to him and I told him about it. I let him and his mother discuss it, and they decided not to go with it. Against my recommendation, I had them sign a document saying I had provided them information about the deal, and they didn't take it. It was not a good decision on their part. So it went to trial, and I tried it, and he was, of course, found guilty. But as a result of that, he serves natural life in prison. That means that he will not get out. until he is dead. And so he didn't utilize that plea bargain. If he'd have done that then, he'd be out now. Because the case, I think, was in 90, I retired in 2000, so it was like 98, 97, something like that, that the case took place. And so he would have been out now and would have been free. And it was a very young kid, would have been in his 30s. So anyway, the point of the matter is that he didn't take advantage of it. So the plea bargaining can be a good tool as well. The criticism is that sometimes plea bargaining is used where a person has forced to plead guilty to something that they really didn't do at all, and that the attorneys, based on some of the evidence, don't have confidence that they could get an acquittal, and they will try to get the individual to accept a plea. Now, that has been associated often with public defenders. I have people say, oh, I want a lawyer. I have a public defender. I said, they're lawyers. There are good public defenders, and there are bad public defenders, just like there are good lawyers and there are bad lawyers that are private attorneys. So the point of the matter is that the plea bargaining is something that takes place with the system. One of the criticisms is it reduces the charges and punishment, and the other is that it deprives the client of a fair trial. That's the one I was talking about earlier. However, be aware that when the person pleads guilty and you don't have to put the parties through the long trial of testifying, and trust me, when you go through these criminal trials, especially when there's murder, and you have to have witnesses testifying that are family members, they have to relive that all over again. And so a plea bargain is often a way to keep them from having to go through that as well. But back to the original point, more than 90% of felony cases, well, you think about that. I tried a lot of cases. That meant that 90% of the cases that I took that were felony cases, not misdemeanors, but felonies, ended up in plea bargaining in many instances. The Supreme Court held that the defendant cannot be punished for refusing to plead guilty and deciding to go to trial. So this person was charged with uttering a forged document. In other words, changing it. The prosecutor threatened to re-indict him on more serious charges if he didn't plead guilty. Can't do that. He chose to go to trial. The prosecutor re-indicted Hayes under the habitual offender law, which meant that that person would either go for a long, long time or never get out, and he was sentenced to life. Supreme Court said, no, this violates due process. So you're hanging it over his head. He has a right to a trial, and you can't hang something like that to re-indict the individual under a charge. Okay? Can't do that. Violates their constitutional right to a trial. The plea bargaining is separate. It's a voluntary thing. It shouldn't be something that you're forced to do. Prosecutorial discretion, I already talked about that, in deciding what charges to bring. Judges are constrained by what we call mandatory sentences, which means there's a range of sentence that the judge is with, or what we call with the mandatory, there are more fixed sentences, and then there are sentences that are not fixed sentences. Prosecutor discretion, though, is not limited. I already told you that. In fact, here, minorities are more likely to be prosecuted and convicted of serious crimes than whites. That's just the way the system is. You can argue it if you want, but that is what happens. I can tell you that from my experience of over 20-something years trying cases. The purpose of determinate sentencing is when the sentencing is set and it removes discretion. Indeterminate sentencing, on the other hand, gives the judges an opportunity to have a wide range of sentencing for individuals. So I worked on Illinois' criminal code when I was in law school in 1977, and I graduated in '78, helping to research the law and adding habitual offenders, Class X felonies, and other serious offenses to give the judges less discretion in terms of sentencing. And even now, since that time, it has gone even further. Good time has been removed. It used to be a day for a day, so 10 meant 5, and that's how it went. So. Pretrial discovery, in which our defense and prosecution can interrogate witnesses of the opposing party, make sure that the trial is fair. If there's evidence exculpatory, I already told you, it has to be disclosed. So the defense must request it. As I already told you in our motion for discovery, as a rule, we request it automatically. So it is a standard statement in the motion for discovery. Prosecution must turn it over if defense doesn't know about it. Prosecution may not knowingly allow perjured testimony as well. So that's the pretrial discovery. We talked about that earlier. In federal courts, it's a little more limited. Evidence given by a witness cannot be viewed before the witness has testified. That's the way it is in the federal courts. There are in-camera inspections. That means that in the judge's chambers where the judge reviews documents, where the prosecution contends they are not relevant to the subject matter to which the witness has testified. So there's hearings that take place outside of the trier of fact, where the judge himself, if he's a trier of fact, will hear the determine whether or not the documents are admissible during trial, and it doesn't become a part of the actual trial itself. Speedy trial, we kind of talked about that a little bit, no specific time. The Sixth Amendment guarantees speedy trials. The Speedy Trial Act of 1974, indictment within 30 days after arrest, trial within 70 days of the indictment. Now remember what I told you, is that you be aware of the fact that many jurisdictions have similar rules. These are the federal ones right here. Defendant can file a motion to dismiss the charge if the time limits are violated. Exceptions where motions by the defense. Remember I told you where you extend the time. Most states have similar rules, and that was what I was talking about a few minutes ago. So therefore, the trial can go longer than the period based on the fact that the defense is waiting for documents or information they need for their defense, or asking for a motion for continuance, or both parties agree to continue, defense and prosecution. It's what we call by agreement continuance. Okay, so anyway, we've kind of already covered that. Okay, and that's it for that one. Okay, so now let's go into this part. Now, be aware now, this is the part where right off the bat, the actual trial itself. In other words, this is that 10% that it says. Less than 10% of all criminal cases go to trial. So now this is what happens if it falls within that 10%. And there's either a trial by jury or either the judge hears. And so based on the Magna Carta historically, jurors are to be peers of the individual, and the jurors had knowledge of the case. In this instance that we have now, they're supposed to be fair and impartial. And so, again, you have a right to a trial by jury. And remember what I said earlier, that it has to be a finding that is unanimous. So now, the Sixth Amendment, right to a speedy and a public trial. Voir dire is proceedings can be closed. Now, what I mean by voir dire proceedings is the proceeding in which the determination of who are the jurors, and they're asked questions as to whether or not they're biased and so forth. That can be closed. It doesn't have to be public. And sometimes it's limited or closed for rape cases or for child victims in courts to protect those individuals. The jury is impartial, as I already said. Be informed of the accusations. And then so there's a right to confront witnesses that you have. So I already told you, you have the due process rights to know what you're being charged with and to confront witnesses. Assistance of counsel. There are what we call instances where individuals agree to represent themselves, but there is, or either pro se, then we have standby counsel. And that usually goes in cases where individuals decide they're going to try the case themselves. The young man who was guilty of killing the people in, I think, North Carolina, South Carolina, Dylan Roof, who sentenced to death, he decided that he wanted to defend himself. And so anyway, the court appointed what we call standby counsel there, even if he wanted to represent himself as well. Impartial jury. In 2003, Scott Peterson was arrested. This was a very well-publicized case for killing his wife and unborn child. He was sentenced to death in 2005. So he was found guilty. And all the publicity. So the judge changed the venue to another city instead of where he lived. But in his appeal, Peterson argued that the change of venue was not adequate. And so the point of the matter is extensive media coverage. And the courts try to protect extensive media coverage by sequestering the jurors, locking them up, and really determining what they read, what they look at, and they can't go home with their families. The O.J. Simpson case, widely publicized case, was an example of that, where individuals are. So the key is to try to do everything you can to try to give the individuals a fair and impartial jury. So a jury versus a bench trial, and the jury, the 12 generally, decides the verdict. And it doesn't involve juveniles, so in juvenile court, because it's a whole different process. Wright applies to cases where punishment is more than 6 months in prison. And an offender with petty charges is not entitled to a jury trial. We talked about that a little early. And then some jurisdictions are a little different. For example, Florida statute includes the right for jury trial for all mala in se offenses. And offenses where you commit a crime and you could possibly end up going to jail. The jury selection generally is 12, some 6. For capital trials or murder trials where you're possibly going to face the death penalty, must have 12 members. And usually there's 14, where there's 2 alternates appointed. And the qualifications are that you're 18 years of age, be a registered voter. And that's pretty much how it's done. It's from the voters pool that in most jurisdictions that jurors are selected. The Juror Selection and Service Act of '68, random selection of panels in federal courts, and of course the compensation is very small. Of course you get paid more. I think you get like $14, maybe $17 in state court, but in jury trials in the federal court, I'm told they get $40-something. So it's a little different. One of my colleagues, she was telling me about that. Voir dire, I already told you about that. It literally means to speak the truth. That's what the word voir dire. Group of citizens whom the jury is chosen, and you can challenge those individuals for what we call cause, which means that there may be a close relationship with counsel, maybe some language barriers, some opinion that they express that they're biased already. I remember even I, as a lawyer, was subpoenaed and had to go to jury duty. And I remember I walked into a courtroom with the jury and was in the jury box one time, and the judge says, "Counsel, why are you over there?" And I held up my badge and showed him. He says, "Okay, stand up." He says, "Do you attorneys both know this guy?" And they said, "Yes." And they said, judge says, "And I know him too. Get out of here, you know." And I got my little $14 and left, and that was it. But it was a challenge for cause because I would, too close a relationship with counsel because we were friends and we knew each other, or we were enemies and we knew each other. So then there's what we call peremptory challenges. These are challenges that are limited in number, that jurisdictions vary, and you don't have to give a reason as to why you don't want that juror. However, though, you cannot use it to stack the jury racially or sexually. I have tried to look at that very carefully, but if the pattern is argued by a defendant, then sometimes the court looks at it very carefully, but usually that's not an issue, at least not in the courts that I've been in anyway. So voir dire is the process that takes place before the actual trial, and that actually there is a trial that's coming and the individual has decided on a jury trial. In Batson versus Kentucky, Supreme Court held that jurors may not be excluded on the basis of race, and we kind of already dealt with that. Okay. Now, dealing with death penalty cases, in capital cases, jurors who oppose the death penalty or have scruples about returning the verdict can be excluded from juries. And in cases where there's a likelihood that the death penalty, if the person is convicted, could be requested by the prosecution. And usually that's one of the questions that's asked during voir dire. In Witherspoon versus Illinois, opponents of capital punishment should only be excluded if they couldn't make an impartial decision. And in Wainwright versus Witt, exclusion if the juror's view would prevent or substantially impair the performance of their duties as a juror in accordance with instructions and oath. And there are people who try to use that to say, well, my job needs me, and those kind of things. Doesn't matter. Doesn't matter. The key thing is that it's a duty. And you know what? To be honest with you, I always wanted to be a juror, but they usually don't pick people like myself because of things that happened. Well, both of my parents were killed, and they probably wouldn't take me. I was a defense attorney, and then I did some prosecution. Then I was a police officer at one time. So I was kind of like one of those persons that, no, never in a criminal case. Well, I can tell you this one by way of a little short story. My oldest daughter, somehow, with her background and her grandmother, who's my natural mother, and grandfather having been killed, and my adopted mother having been a victim of a crime, she still was selected to the jury, and I was surprised. She became the foreperson, and in fact, she hung the jury. There were 11 people in there who said nope, and she was the lone one who said, no, I'm not changing no matter what. So they ended up with a hung jury, and then they retried the young man, and then he was found not guilty. So I guess she was right. So anyway, the point of the matter is that jurors have to be fair and impartial, or should be. In Rivera versus Illinois, the U.S. Supreme Court held that a trial judge's erroneous denial of a defendant's peremptory challenge didn't constitute an error that was sufficient. They call them harmless errors. Rivera's attorney submitted a peremptory challenge for a juror, but the challenge was denied by the judge. The court held that this was an error by the judge, but that it was harmless. Well, we as lawyers, again, defense attorneys, say we don't know what that is because we don't know what the potential effect of errors could be in terms of determining whether or not the jury finds a person guilty or not. So we think that that's a misnomer in a term, but it's used all the time in the appellate court to determine that they won't grant a new trial because they use this term harmless error. But the point of the matter is that what they're really saying is that it was de minimis. But we argue against that all the time from a defense perspective. Okay, we talked about this. Jurors not supposed to discuss the case with anyone. We talked about O.J. Simpson case where the jurors were sequestered. And then there are instances where the press is not allowed to write about certain things. Cameras are now being allowed in some states, as you already know, California, because the entire O.J. Simpson case was, in fact, on television. And then I actually did some reporting here in Illinois about that. One of the best jobs I ever had, where I sat at home and got paid really good to report on the case, and then also 3 stations I did for. It was a nice job. But anyway, the point of the matter is there were cameras in the courtroom, and you've seen court TV in jurisdictions where they are. Illinois is finally heading in that direction. Gag orders, which the court says nobody talks to anybody, especially the media, prohibiting attorneys, witnesses, jurors, and others from talking to the press about the case. If you violate that, you can be found in contempt of court. Here's a case that became a movie, actually, in which this gentleman by the name of Sam Shepard, it says the Supreme Court held that intense media coverage may prejudice the jury, which is a violation of due process. Sam Shepard was convicted of murdering his wife in a trial in which the jury was greatly influenced by intense media coverage. In other words, they were able to know all about it and see all the things that the media was saying. The court overturned the conviction. Shepard was found not guilty on retrial. His son then filed a civil suit against the state of Ohio, claiming that his father was wrongfully incarcerated, but that the claim was rejected by the jury. But the point of the matter is that they weren't sequestered. They really should have been, and that would have been avoided. Nebraska Press versus Stewart, in which the court held that a gag order is constitutional to protect the fairness of the trial. The court had issued a gag order in a trial where the defendant was charged with 6 murders and sexual assault of a family. The trial received much attention in the media, so the judge imposed a gag order. And then so the press argued that the gag order violated the First Amendment. They said no, because the fundamental right of the individual to a fair trial weighed heavier in that instance, with the balancing concept that was used to determine the constitutional rights of the individual to get a fair trial overrode the right to the media under the First Amendment. Judges have a lot of power. They need to keep order in the court, maintain contempt. You guys remember the situation that involved the case in Florida that we had the video a few weeks ago, where an individual was unruly in court. The power of contempt is to punish someone who insults the court. The court should protect the individual's right to a fair trial, and defendants can be removed from the trial. I remember years ago there was some conspiracy trials that took place in the federal courts. There were individuals who had to be gagged and tied in the courtroom by the judge at that time. It was a very interesting situation where these individuals were jumping up, screaming and cussing and all kinds of things. So unruly defendants had to be removed from the courtroom. Behavior of counsel, you have to follow the legal and ethical rules. You shouldn't express personal opinion or inflame the jury. You can't say things like, in my opinion, if I were you, jurors, you can't do that. It would get you in trouble. Judge can discipline lawyers for misbehavior, reprimand, or refer them to the Bar Association. Also, it goes to attire as well. If you saw the movie My Cousin Benny, the judge determined what to wear. I remember one time I was doing a case in Indiana, and I went there and I had a not collarless shirt, but I had a button-down shirt with a suit and everything. But the judge in that courtroom gave me a continuance because I had asked for one, told me the next time I come to her courtroom to make sure I have a tie on, a shirt with a tie, and that was her rule. So I did. Otherwise, I've been found in contempt of court. The rules of evidence. Rules of evidence is what controls what can be presented at trial. Verbal statements, writings, documents, photographs, tangible items that prove or disprove some fact. And the court can take judicial notice of evidence. The standard of proof is beyond a reasonable doubt, and all evidence must be relevant. You can object to evidence. You and the federal rules of evidence is adopted in most jurisdictions in almost every state of the union. Not Florida, but Louisiana is the only state that might be different because they operate under Napoleonic Code. The other jurisdictions operate under the Civil Code, which comes from England. So the Napoleonic Code is from France. So at any rate, in the rules of evidence, there are exceptions like hearsay, dying declarations. There's a whole myriad of them. I teach a class on criminal evidence, and I cover all of those in that. But the evidence must be relevant, and it can consist of written as well as oral statements from the stand. Now, be aware that in criminal cases, opening statements and closing statements is not a part of evidence. These are just summaries. The evidence is what's in between that the trier of fact, whether the judge or the jury hears to determine whether or not that person is guilty of the offense. Similar fact evidence refers to evidence of facts similar to the facts alleged in the crime charge. Prior crimes may be admitted. The only way prior crimes can be admitted is if the defendant takes the stand. If the defendant does not take the stand, prior crimes may not be admitted. Those prior crimes will be used against an individual, sometimes who had some others, what we call priors, to impeach them or discredit their testimony. Classification of evidence can be what we call real evidence. That's evidence that you can see it, touch it. Direct evidence. This is evidence that goes directly to the issues of the trial. And then there's indirect evidence that kind of is akin to it, but it's not as far as circumstantial. It's kind of in between that. Eyewitness testimony, most unreliable form of testimony ever presented. When I was in law school, our professor did an experiment to show us that eyewitness testimony was not reliable. What happened is that we were in the lecture hall. There was about 60 of us students in there, and a person ran in and grabbed the professor's wallet off of his desk and ran out. He obviously had set us up for it, and then told us to take out a piece of paper and write a description of that individual. And boy, you should have seen the variations of descriptions that we had. So that's when I say eyewitness testimony is probably the most unreliable form of testimony. I've discredited people many times in court for eyewitness testimony. It's 10 o'clock, but we're going to go ahead and we're just about finished with this. Experts testify, and forensic experts, medical experts, handwriting experts. Those individuals must be properly credentialed. They're subject to cross-examination. May respond to hypothetical questions because it's based on the area or field that they're an expert in. There's a section called voir dire in this, which means you're questioning the expertise of the witness to determine whether they're qualified or not. But these are the various witnesses that take place. These are very valuable witnesses. I've won cases with all of these, using all of these to help me in terms of determining that my client did not commit an offense. And then these are some examples of expert witnesses. I'm going to flip over. Scientific evidence. Evidence obtained through scientific and technological innovations are what we call the generally accepted tests. In other words, generally accepted in the field or industry. Polygraph tests or the lie detector tests. They're up and down. We can prove with experts that polygraph tests don't exactly, they used to call them, they hate lie detector, but it determines that you're not telling the truth. But there's ways we as attorneys know very well, as defense attorneys, how to defeat them and make them look like they're not really that strong in terms of whether that person's telling the truth or not. Same with prosecution too. Hypnotically enhanced testimony is also used in cases. In many cases I've seen, none that I ever had, but I've been in court and seen it take place. Battered women syndrome, where it's used in a situation where a person eventually kills the person who was beating them down through the years or months and days, and they use that as a defense, and professionals are provided there to testify or called upon. The most revolutionary change is this one at the bottom, DNA. We didn't have that when I left. It was on its way in. It is the most revolutionary scientific evidence, and of course has been responsible for exonerating many individuals who it was determined after they even served many years in prison or jail that they didn't commit the offense. Very, very good process. Objections. We can object in court against a witness or testimony. Hearsay, which is testimony where one person is saying they heard somebody say, that's hearsay. We can object to that. We could say that the information is not the best evidence, that it's primary evidence to use to prove a fact, or that it is the best evidence, that is the primary evidence used to prove a fact. Or we can say that a question calls for an opinion. Testimony must be based on facts, unless, again, remember, you're dealing with experts. Okay. The Supreme Court held that in all criminal prosecutions, the accused enjoys the right to be confronted with the witnesses against him. In this trial, the prosecutor introduced a recorded statement from his wife in which she stated that she did not act in self-defense. The Crawford appealed, arguing that the pre-recorded statement violated his right to confront witnesses against him. And you have to be able to, you can't cross-examine the tape. There's privileged communications where there's attorney-client, can be claimed by the defendant and his attorney. The client can waive the privilege, but the attorney cannot, except if the attorney survives the client's death, then in that case, there's no longer a need for it. marital privilege. We don't want husbands and wives testifying against each other in cases where a husband is charged, not where they're the victim. I'm talking about where a statement that they're familiar with their husband or wife involved, they can't use them as witnesses because of the marital privilege. The same thing with clergy, priests, ministers, and rabbis. These are all limited. There are certain exceptions to it. Same with doctor-patient privileges as well. In other words, we want to try to get individuals to tell the truth to these individuals, clergy as well as doctors, especially doctors, so that they can determine the issues that they need to treat that patient. Judge is the umpire, rules on motions, instructs the jury, has wide discretion, but held accountable by the appellate court. So if they make a mistake that's not harmless error, it can be the basis for a new trial or overturning a ruling that the judge has issued. Opening statement is when the prosecution and defense outline their theories. Defense can defer opening statements. Again, remember, these are not parts of evidence of the trial. We got one or two more to go. Prosecution and defense calls witnesses, as I told you, lay witnesses versus expert witnesses. We've talked about that. There's a right to confront and cross-examine based on the Sixth Amendment. Leading questions can be are asked on cross-examination, but not on direct examination. Leading questions are questions that lead the witness to an answer or suggest an answer. Witnesses may be subject to impeachment, which means they can be caught in not telling the truth. That happened all over the movie My Cousin Vinny. Child shield statutes. We talked about protecting children in terms of testifying, requiring in-camera or hearings outside of the public. Defense can move for a judgment or directed verdict, which means that the prosecution didn't meet the burden of proof beyond a reasonable doubt, and the judge can grant that motion if, in fact, that's the case. I've won a few cases like that. Defendant taking the stand, I already talked about that. You have a Fifth Amendment not to, is a strategic decision. The prosecution can cross-examine the defendant, again, because of priors, or if I have a client that I usually refer to as has diarrhea of the mouth. They just like to talk. I won't put them on the stand because they're going to mess up. Rebuttals, these are witnesses that come back after the case. I had a client one time that I remember off the top of my head, had the case won. And we got to the end, and then the prosecution requested a continuance to provide a rebuttal witness, and said the rebuttal witness is going to provide testimony to contradict what has been presented so far. And so I had already told my client, when you're incarcerated, don't talk to anybody. Well, the next day, the witness came out, and they said the person's name. I had asked my client about the name. He said they didn't know him, but when he walked out, my client started cussing, and I said, okay, Judge, I need a continuance. Give me a brief period. Just give me 10, 15 minutes to talk to my client, and I did. I discovered that my client had talked to him contrary to what I told him, and as a result of his testimony, he ended up going to jail. So the rebuttal witness came back and just tore down everything that had been established before that. Conduct of the jury, they listen to the evidence. Judge can allow questions for witnesses. And then there are the closing arguments. Then the judge gives jury instructions, giving them legal terms, and provides them with what we call a pattern of jury instructions in our jurisdiction, explain possible defenses. The judge doesn't summarize the evidence, but just gives them the elements of the crime so that they can determine if all these elements of the crime were met to determine whether or not the individual is guilty of a crime, or they can instruct them of lesser offenses, but instruct the jury that they are the sole trier of fact, okay, and explains the defenses possible. The jury selects a foreperson, is in secret, in many cases sequestered, as I talked about earlier. Deadlock juries is when a jury cannot agree on a verdict. I already told you about that. That happened with my daughter. Allen charge, that means then that the jurors are then polled to determine how close they are, and then if they are far apart, then a hung jury takes place. Juries can be pardoned because that they later on find that the jury lied in voir dire, or the jury finds the defendant not guilty despite the evidence. If it's like way out there and they find the defendant not guilty, then then a motion can be requested by the prosecution to overturn that. O.J. Simpson trial, I already talked about that. Verdicts are written. The jurors are polled to ask if each juror is their verdict. Then they answer yes. Then the verdict is then read. If there's a no in there, then the judge sends them back. Post-trial motions then are presented, where if the defendant is found guilty, then there's a motion for a new trial, and the notice of appeal is filed, and then the document alleging that errors were committed at trial, usually denied, but then that starts the process for the appeal. And that's the whole thing in a trial and how it works. So that's it. I hope that you have enjoyed this quarter. I hope that you learned some things about this area of criminal law. I will tell you this, that I will be teaching this course next quarter, but they have a new format. It is no longer going to be 11 weeks. It is going to be 2 sections. Well, the course is going to be 5.5 weeks itself. And I already looked at the 5.5 week course. I like it. It is really exciting. We use a different book. We use different materials. There are lectures every week, and the students have to attend the lectures or the archive. So I'm excited about teaching that course starting in the spring quarter. So at any rate, those of you who have issues, make sure you get those issues cleared up. I already told you when the quarter ends. There are no exceptions. Well, I shouldn't say that, because if there are exceptions, you know what they are, then we operate on that basis. I'm a part of that, along with your deans as well. So the point of the matter is that there are things that we can do. But the key thing is to get your assignments completed, following all the processes as I've told you from day one. So with that, I'm going to say good night to you, and enjoy.